Darryl, thanks so much for being with us. You're a member of the Law Council of Australia's Elder Law and Succession Committee. What do you see as the issues for lawyers in dealing with elder abuse?
Elder financial abuse is probably the area where lawyers can be most helpful because we can be proactive in helping prevent elder abuse occurring in the first place, elder financial abuse. So that's the most important aspect.
But how can you safeguard a client against that?
If we properly prepare and help clients to identify what the issues are that can come up. So one of the issues, for instance, that comes up is that sometimes people appoint as their attorney or their informal agent somebody who just doesn't have the qualifications or the experience or, the general attitudes that a person needs to have to look after somebody else's legal and financial affairs. So identifying that and challenging to an extent the client's understanding of what the role will be, the attributes that are important in fulfilling that role, and then going through and talking to that person about their individual circumstances. So just like your will and my will be different, because your circumstances are different from my circumstances, so should be your enduring document. So your enduring power of attorney or your enduring guardian appointment form should be quite different from mine, because your situation will be different to mine. So going through and talking about our individual circumstances and working out what would need to be done. So if you're delegating to somebody the ability to look after your legal and financial affairs, what will that mean? What are the decisions they can take? What there is the risk issues that can arise as a result of that?
But isn't that normal practice now? Isn't that what every solicitor would do now in preparing those documents?
Probably not. One of the reasons is that when there was a reform of the law to change powers of attorney from being a document where every single power needed to enumerate it to a very short form document which included all powers, unless they were excluded, was there was a little bit of a turn-off from engaging in exactly what powers needed to be done. Now, the law reform was done because the documents which had to enumerate every single power became unwieldy. It exposed attorneys to risk which no sane person would probably want to take, and therefore there needed to be change. But it's like lots of things. When there's law reform, you can go from one extreme to the other, and that's effectively what's happened. So we need to move there to a balance. We need to get clients to expect this to occur, and we need to get lawyers to engage with clients to run out these risks.
And to what extent at the moment are you dealing with a situation where lawyers might encounter a client where that care and diligence hasn't been taken and they see the consequence of that? They just deal with the aftermath of it.
Look, there's lots of occasions where that occur. And they come before the courts, they come before the superior court, so it's the Supreme Court of the state or territory, and the issue has been, how did we get here? Now, with hindsight, you can go back and say, more care should have been taken. There were 3 cases came before Superior Courts last year, which shows how enduring powers of attorney can be abused. The first case was from New South Wales. It was a blended family. The second wife, at the time she acted as the attorney, because she was appointed as the attorney for her husband. He had an estate of $1.5 million. He had a will which left his estate half to her and half to his 2 children from his first marriage. Now, when she engaged in looking after his legal and financial affairs, she then used money to pay for a trip for herself and her side of the family, for expensive motor vehicle, for expensive jewellery. She bought property for her daughter and son-in-law. She put a granny flat on that property. And so at the time of Mr. Smith, was the name of the man, and Mr. Smith's death, after 3 years, the estate was worth $75,000. So a blended family causes a particular type of issue because you've got that split allegiance. There's an allegiance that Mr. Smith probably had to Mrs. Smith, one would expect, but an allegiance he obviously had, because he expressed in his will, to his children from the first marriage. So that was where she was held to have abused her position as the attorney. The children could then recover the property which had been put into the name of the daughter and the son-in-law because it was the proceeds of her abusing her position. There was a case in Victoria where a daughter was appointed as the attorney and by reason of that appointment was able to let her father's house to her husband and put it specifically into his name so that it wasn't a suggestion of conflict of interest, but occupied it with the husband and their children, and took something like $1 million out of his family trust and put it into speculative investments, appointed themselves as the controller of the family trust. So when eventually monies weren't being paid on behalf of Mr. Ash, was the person in that situation, when the monies weren't being paid and an administrator was appointed, similar to a financial manager in New South Wales, the administrator then took action to recover those funds. And then the last of the three that highlights the types of issues that can come up was a matter of Riley. And what happened in that was a nuclear family situation. But Mr. Riley had decided to leave his farm to his son. Now, that was, at one stage, what most farmers did. But when he went into the fog of dementia, as the judge called it, then the wife took over as the attorney. She decided that wasn't fair, that they also had 4 daughters, and that the farm should be transferred into the name of the 4 daughters. So she, as his attorney, transferred the property into the name of the 4 daughters. Mr. Riley then died, and the son said, well, I should have been left that property. I'm going to take action against my sisters to recover those funds. And unfortunately, in that situation, the solicitor was held negligent, as well as the fact that the daughters were told they had to disgorge that property. And the solicitor was held negligent because the solicitor hadn't told the mother, the wife, the attorney, you can't do that. If you think it's unfair, there are other options that you may want to explore, but you just can't take it upon yourself to change a person's property interests.
And so all of those indicate that if you don't get the drafting right, that if you don't take the time at the beginning, you expose your clients to risk and harm and yourself to risk and harm.
Totally. Yeah. And of course, so it's in everybody's interest. It's in the client's interest, it's in their family's interest, it's in the lawyer's interest. Yeah. So the whole scheme. And
why do you emphasise this element of the law so much? Do you think that if you get this right, if you reform practice in this area, it would make a big difference?
Yes, definitely. Look, if you come from the perspective that elder financial abuse is the biggest area of elder abuse, and you then look at how that is made up, there are some aspects of that lawyers are never engaged in. So, for instance, a person who deals with their bank and because of informal or formal arrangements made with the bank is a victim of elder abuse, elder financial abuse, a lawyer will never be involved in that sort of transaction. But in something like enduring documents, the lawyer will almost always be involved and should be involved. And so it's in that sort of area that lawyers can be quite active about prevention, so it doesn't happen in the first place.
And you're not confident that the Law Reform Commission's proposal to have a register of these arrangements, these enduring powers given to other people to run the financial aspects of an older person's life, that registering that in a central place would make much difference to the rates of abuse?
Yes, I don't think that well, firstly, it's going to have to be financed, how it's going to be set up, what information is going to be recorded, because if the example they've given of the personal property security register is adopted, then all you'll be doing is registering the fact that the person's got a power of attorney, but nothing else. It'll then mean that a person needs to access that. Now, in the general community, people won't know about it unless there's a mass promotion. Who's going to finance that? So I just feel that that's not necessarily going to be the best way of addressing this problem. If government says we're going to finance that, then quite frankly, I'll be saying, there's better ways to direct your money.
And where do you think we are, if today is year 0, where do you think we are in starting to make the sort of cultural and changes in professional practice that need to happen to clamp down on this?
Oh, well, we're a long way ahead of where we used to be, and we're heading in the right direction. My fear is that we can be diverted too easily. I hope that isn't the case. this national conference, I hope, will make sure we're pointing in the right direction. But for instance, I think it's very important there be a national response, but that's not our top line interest. Our top line interest should be prevention. Our second line should be redress for those people who are the unfortunate victims. If we can get those two right, then hopefully we can get to the third point, which is a national response. But I'd hate to see a national response which produces the lowest common denominator, which sometimes I've seen advocated, rather than the highest common denominator. So we've got to work at the best practice for prevention, the best for redress, and then bring all that together.
Wonderful to talk to you. Thanks so much for making the time.
Pleasure.